Is this right as strict as in a pure private context in your household? No, it is not. It is a contextual right that needs to be judged, taking into account the concrete circumstances of the case. So this means that a judge, of course, will have to take into account that he is in a company, a professional environment where the privacy is not that high as in a pure private context, but this is the difficulty, the border between this private and professional aspect within a company. This is what makes it difficult to deal with it. European Court for Human Rights since a long time uses 3 principles in order to elaborate whether breach of privacy is legitimate or illegitimate. And to be legitimate, these 3 principles have to be met with are the principle first of finality, secondly of proportionality, and thirdly of legality. I explain them slide by slide. First principle is the principle of finality, which means you have to have a right purpose, a right aim. We can refer to one of the slides before, the slide where we elaborated the Article 8 of the European Convention of Human Rights, where, for example, for private investigation is referred to the interest of national security, openbare orde publiek, or the prevention of disorder or crime, which are, according to the European Convention of Human Rights, legitimate purposes which a legislator can use to make a law that allows you to breach into someone's privacy under certain conditions. So for private investigation, I think there's no much discussion on the fact that the aim, the purpose of fraud prevention and fraud detection is as such okay. So there is no problem with the principle of finality normally. Second principle is the principle of proportionality, which means that an investigative measure, a private investigative measure which has been taken, needs to be necessary. What does this mean? Well, this means actually that for every private investigative measure that you take, and that is what we always advise to our clients, to companies who are doing fraud investigation or to fraud investigators, that for every investigative measure you have to take into balance the facts you are investigating on the one hand and the measures you are taking into account on the other hand. And for every measure you have to make the exercise, is there a less privacy intrusive way in order to obtain the result, in order to obtain the proof, the potential proof of fraud? So this is a case-by-case exercise which has to be done in a private investigation, and we always advise to document, to motivate into your report when you make an investigative measure, certainly a measure which goes quite far in terms of privacy intrusion, that you motivate, that you document well in your report why you took this measure and not a less privacy intrusive measure. Third principle is the principle of legality, which used to be the most difficult one, actually, because while we are here in the context of private investigation, it's not a public investigation. In a public investigation, this is all regulated by law. You have the Code of Criminal Procedure. You have other acts which give government institutions or persons working for government competences to make an investigation. This is not the case for private investigation. There is no such thing as a private investigative act which allows you, which gives private investigator certain competences. And then we refer again to the basis of the privacy, the right on privacy, which is the Belgian Constitution in Belgium, which says that in order to do a privacy breach, that you need a legal basis. It needs to be regulated by law. So long time there was discussion, well, how do we deal with this for private investigation? Well, it is actually the former Privacy Commission, nowadays the Commission for Data Protection, that gave in 2012 already, from its own initiative, a recommendation, because it's got a lot of questions according to or regarding privacy in a professional context, in a company context. And the Privacy Commission actually said, well, we can use the Article 16 of the Labor Agreement Act, which is actually the general act in labor law, which allows an employer, which gives the employer a legal mandate to exercise surveillance and control on his personnel. So the Privacy Commission says, well, this is the legal grounds which in a relation employer-employee can be used in order to execute private investigation. Does this allow an employer to do whatever he wants? Can he go as far as he wants because he has the right to control according to Article 16 of the Labor Agreement Act? Well, the Privacy Commission says no, and this is what we apply when we advise for companies. We did this for some banks already, for example. The Privacy Commission says you have to specify this in a policy which needs to be transparent, known to the employees, which needs to be enforceable. They have to know what you are up to in a company, which has to be embedded within the limits of exceptions and guarantees provided by the law, amongst which it still refers to the Privacy Act, now the GDPR. So actually, how do you do this? Well, it has to be in accordance with, according again, the Privacy Commission. It has to be in accordance with normal company management, and in accordance with all other relevant legal and also regulative provisions within the company, amongst which collective labor agreements, and then it refers, we will talk about it later, to the CAO number 81. So important, you can give the next slide, important for the principle of legality for private investigation. It is okay as long as the company has a transparent and enforceable rule that allows a concrete way of privacy intrusion. When the company says, look, we have made it enforceable and transparent to our employees that in this company it is possible that, to give an example, that the internet traffic is controlled. So the principle of legality can be met in this way. In practice, how do we do this when we are asked to assist a company in implementing this recommendation, if you want? Well, we start, of course, by looking what does exist already. Is there a labor regulation? Is something described in the labor agreements? Are there guidelines, formal, informal, in no matter what way? But we mostly end up, or we try to end with the editing a fraud policy, where we gather everything, where we bring everything together, and where we says, look, this is a fraud policy, which we will, once it is agreed in the company, which we will make transparent and enforceable, or which the company has to make transparent and enforceable towards its employees. And what do we describe and determine in this fraud policy? Well, first, finality, the aim and scope of private investigation. What does the company provide? Is this only for fraud, or is this also for example, personal, relational aspects, sexual harassment, etc.? Secondly, who is responsible for this within the company? Which entity? Is there a fraud department? Is this the internal audit? Are there specific persons? When there is a whistleblowing system, we also describe the whistleblowing system, and this will be something which will, in the next in the next year or years, which where the fraud policies will have to be adapted, I think, according to the European legislation to be implemented by the Belgian law. We also describe important which competences, what can a private investigator do based on this Article 16 of the Labor Agreement Act. And we describe the procedure for an interview, for drafting report, data retention, how long can you hold data, which is in accordance with the GDPR, of course, confidentiality, and so on.